In 1215, a church council banned priests from taking part in trial by ordeal. And across Europe, a legal system that had run for 400 years collapsed almost overnight. Before that year, if your neighbor accused you of theft, the court might not weigh a single piece of evidence. It might heat an iron bar until it glowed, hand it to you, and watch you carry it 9 paces. Then it would bandage your burned hand and wait 3 days to see how the wound looked. That was not a punishment. That was the verdict. We tend to picture medieval justice as cruelty for its own sake. Torture, dungeons, a lord doing whatever he liked. The reality is stranger and much more organized than that. Medieval courts had rules. They had procedure. They had forms of proof so exact that getting one word wrong could lose you everything. What they did not have was any way to find out what actually happened. So they built a system that did something else instead. You are about to see how an ordinary accusation moved through that system, how your reputation was worth more than your alibi, why 30 of your neighbors swearing an oath could beat an eyewitness, what the water and the iron were really measuring, and how a man could be declared, by law, no longer a person at all. Everything started with a voice, not a document. Someone stood up in front of the community and said your name out loud. There was no police force, no detectives, no public prosecutor gathering a case against you. In most of medieval Europe, a criminal accusation was a private act by a private person, and it carried a real cost to the accuser. If you accused someone and lost, you could be fined. In some codes, you could be whipped. The system was built to make people think hard before they opened their mouths. That sounds like a protection. In practice, it worked differently. Because the accusation had to be public, and it had to be immediate. In Anglo-Saxon England, a man who found his cattle missing was expected to raise the hue and cry, shouting until neighbors came running, and every able-bodied man who heard it was legally required to join the chase. Not to investigate, to chase. The mob that formed was a legal instrument, and the law expected it to catch someone. Speed mattered more than accuracy. A thief caught with the goods still in his hands was called a hand-having thief, and in many jurisdictions he could be hanged the same day, with no trial at all. The goods in his hands were the trial. Now imagine you were not caught holding anything. You were simply named. Here the shape of your whole life became the evidence. Courts asked what your reputation was, not what you did on the night in question. What you were, generally, in the view of the people who had known you since childhood. A man of good fame walked into court already half acquitted. A man of ill fame walked in already half condemned. Your neighbors were the case file. This is where the system starts to look alien to us. We think of character evidence as a weak supplement to hard facts. For them, character was the hard fact, and it was the most reliable data the court could actually get. Nobody could dust a barn for fingerprints. Nobody could establish a timeline. But 200 people in a village of 200 people knew exactly which men drank, which men fought, which men had been suspected before and never quite cleared. The court was not looking for the truth. It was looking for a way to end the dispute without the village tearing itself apart. Because the real danger, the thing medieval law was actually terrified of, was not that a guilty man walked free. It was the feud. An unresolved accusation between 2 families could produce killings for 3 generations. Every procedure you are about to see makes more sense once you understand that the court's job was to stop the bleeding, not to reconstruct the past. So the first question was never really, did he do it? The first question was, who gets to swear? Your defense was not a statement of facts. It was a sentence you had to say perfectly, out loud, in front of everyone. Oath-taking was the ordinary form of proof in early medieval courts. And it was not casual. The oath was a formula, fixed words, in a fixed order. sometimes in Latin, sometimes while touching relics or a gospel book. You had to deliver it without stumbling, without correcting yourself, without a pause in the wrong place. If you fumbled the words, you had failed the proof, not lost a point, failed. Legal historians call this bursting the oath. The Old Norse and Old English sources treat a broken formula as a decided case. The theory behind it was simple and, in its own terms, coherent. You were not making a promise to the court. You were calling down God's judgment on yourself if you lied. A man willing to do that was staking his soul, and a man whose tongue tangled in the middle was understood to have been stopped. Then it got harder. For any serious charge, your own oath was not enough. You needed oath helpers, compurgators, men who would stand beside you and swear, under the same terms, that your oath was clean. The number required scaled with the charge. 12 was common. For grave accusations, the codes demand more, and some texts require the helpers to be drawn from specific groups, freemen only, or men holding land, or kinsmen on your father's side rather than your mother's. Here is what those men were not doing. They were not testifying that they saw anything. An oath helper who had been asleep in his own house all night could still swear for you, and his oath was valid. He was not swearing to the event, he was swearing to you. He was putting his own soul at risk on the proposition that you were the kind of man whose word held. That is why the number mattered so much, and why the requirement rose with the seriousness of the charge. Getting 12 men to gamble their salvation on your character was a measurement. It measured how much credit you had in that community, and credit could be spent. If you had feuded with half the parish, you would not find 12. If you were a stranger, you would not find 12. If you were poor and had no kin nearby, you would not find 12. The oath system was, functionally, a wealth and belonging test wearing the clothes of a religious ritual. Insiders passed it. Outsiders failed it before the hearing began. Which raises the obvious problem. What happened when the court could not use oaths at all? Sometimes the oath route was closed, and then the court reached for iron, water, or fire. Ordeals were never the everyday method. That is the first thing to correct, because the popular image has it backward. Ordeals were the fallback, used when the normal machinery jammed, when a man was of such bad reputation that nobody would swear for him, when the accusation came from a lord and could not be brushed aside, when two parties both produced full sets of oath helpers, and the court now had two complete proofs pointing opposite directions. At that point, the court handed the question to a higher authority. Forms varied by region and by century, and the details are more precise than you would expect. In the ordeal of hot iron, the accused fasted, heard mass, and carried a heated iron bar a set distance, often 3 paces or 9 feet. The hand was then wrapped and sealed. 3 days later, a priest unwrapped it. A clean wound meant innocence. A festering wound meant guilt. In the ordeal of cold water, the accused was bound and lowered into a pond or river. And the logic here runs opposite to the witch trial version most people have heard. In the medieval ordeal, sinking was acquittal. The water, blessed as pure, was understood to receive the innocent and reject the guilty by pushing them up. Floating condemned you. There was also the ordeal of the morsel, mostly for clergy, where the accused had to swallow a piece of bread or cheese of a fixed weight without choking. And in the ordeal of the cauldron, the accused plunged a bare arm into boiling water to retrieve a stone. Read those, and something becomes clear. These are not efficient ways to kill people. Every one of them has a delay, an interpreter, and a margin. The iron ordeal does not ask whether you were burned. Everyone was burned. It asks a priest, 3 days later, to look at a wound and make a judgment call about whether it is healing cleanly. The water ordeal turns on how a bound body floats, which depends on lung volume, body fat, and how the ropes were tied. The morsel depends on a dry mouth, which depends on fear. Discretion was built into every step, and the men running it knew that. Modern research has found what you might expect from that design. In studies of surviving ordeal records, a striking share of the accused pass. One analysis of medieval Hungarian ordeal cases found roughly 2/3 of those tested were cleared. That is not what you get from a lottery, and it is certainly not what you get from a system trying to convict. So what was actually happening? The best explanation is that the ordeal worked on belief, not on physics. If you genuinely believed that God would burn a liar's hand and protect an honest one, then agreeing to the ordeal was a signal. The guilty man, believing the same thing, had every reason to settle, confess, or flee before the iron came out of the fire. Many did exactly that. The records are full of cases that end in settlement at the moment the ordeal is ordered. The court was not looking for the truth. It was offering the accused a decision point and reading his answer. And for the ones who went through with it, a sympathetic priest with a 3-day window and no fixed standard for a clean wound had a great deal of room to deliver the outcome the community could live with. The word verdict comes from words, meaning a true saying, and for most of the Middle Ages it was not a conclusion drawn from evidence at all. Early juries were not what we mean by juries. When Henry II's reforms in the 1160s began putting groups of local men under oath to answer the king's questions, those men were chosen precisely because they already knew. They were not blank slates to be persuaded in court. They were the local memory, summoned to state what the neighborhood held to be so. A juror who knew nothing about the case was useless. That inverts everything about a modern trial. Today, we screen jurors to remove anyone with prior knowledge. Then we build the case in front of them from scratch. Medieval practice screened for prior knowledge because the whole point was to extract the community's settled view and give it the force of law, which means the verdict was often decided before anyone spoke in the hall. And the hall itself did not look like a courtroom. Many hearings happened outdoors. 100 courts met at a stone, a tree, a bridge, a crossroads, on a fixed schedule everyone knew. There was no bench, no dock, no gallery. Business was noisy, procedural, and mixed in with land transfers, debts, and boundary disputes, because these were not criminal courts. They were the local government, and crime was one item among many. Time in that world was not neutral either. A case could be lost on procedure, show up late, fail to produce a required person, use the wrong formula, and you were done, regardless of what happened on the night in question. The forms were the substance. Then there was the alternative nobody talks about enough. Most disputes never reached a verdict at all. Settlement was the normal ending. The parties came to terms, often with the court's active encouragement, and money changed hands. Anglo-Saxon law even published price lists. Wergild, man price, set what a life was worth by rank, and there were fixed compensation figures for lesser injuries too, running down to individual fingers and teeth. A killing could be paid for. That looks monstrous to us. Look again at what it was for. Wergild was a feud stopper. It gave a grieving family something to accept other than blood. And it gave the killer's kin a way to end the matter with property instead of more corpses. The tariff was public, so that neither side could argue about the amount. The point was closure, priced in advance, and the whole apparatus of oath and ordeal existed mainly to establish who owed it. But there was one outcome worse than owing. If you refused to come to court, or fled before judgment, the court could stop treating you as a human being. Outlawry was not exile, and it was not a sentence to be served. It was a legal status change. The outlaw was put outside the law's protection entirely. His property could be seized. His marriage bonds could be treated as dissolved. He could be killed by anyone. without penalty, and the killer owed no Wergild, because a man who was outside the law had no price. Medieval sources describe the outlaw as a wolf's head. The comparison is literal and administrative. He was vermin, and there might be a bounty. Sheltering him was a crime. Feeding him was a crime. In practice, that turned everyone he had ever loved into a legal risk. And it is here that the system's real engine becomes visible. Outlawry did not need a police force to work. It converted the whole population into the enforcement mechanism, and it did so by making neutrality illegal. Watch how efficiently that solved the state's central weakness. A medieval king had almost no capacity to hunt one man across a forest. He had no standing police, no reliable roads for pursuit, no records to circulate, and no way to recognize a face he had never seen. What he did have was every farmer, every miller, every innkeeper, and every priest in the country, all of whom now had a direct personal reason to turn a stranger in. The manhunt was outsourced to the population, at zero cost, by a single change of legal category, and the status was contagious in one direction only. Harbor an outlaw, and you could be treated as one. That threat did not need to be carried out often to work. A wife who fed her husband in the woods was committing a crime, and everyone in the village knew it, which meant the pressure on her came from her neighbors long before it came from any official. The community policed itself, because the alternative was shared liability. Records show the status was also used as leverage rather than as a final judgment. Many men were outlawed simply for failing to appear, then quietly restored once they turned up and paid. Outlawry in those cases functioned as a summons with teeth, not a conviction, which means a large share of the men legally classified as wolf's heads at any given moment were not murderers or thieves at all. They were people who had missed a court date and could not afford the fine. Consider what that meant for someone who was actually innocent and simply afraid. A man wrongly accused, with no oath helpers, facing an ordeal he did not trust, had a terrible choice. Stay and submit. Or run, and by running, become a wolf's head. Many ran. That is why medieval forests filled with men who had never been convicted of anything and could nonetheless be legally hunted. The Robin Hood stories grew directly out of that soil, and they are less romantic than they look. An outlaw band was not a rebellion. It was a group of legally dead men with nowhere else to be. There was a way back, and it was narrow. A pardon, sometimes purchased, sometimes granted for military service, sometimes obtained through sanctuary in a church which bought a fixed number of days, often 40, to negotiate exile instead. A man could kneel, confess to a coroner, surrender everything he owned, and walk to a designated port carrying a wooden cross to leave the kingdom forever and live. That was the good outcome. In November 1215, the Fourth Lateran Council forbade clergy to bless the instruments of ordeal, and the whole structure lost its foundation in a single stroke. The reasoning was theological, not humanitarian. Churchmen had been uneasy for a long time about the idea that God could be summoned, on human schedule, to burn a hand or float a body on demand. It looked less like faith than like putting God to the test. Without a priest to consecrate the iron and the water, the ordeal was just an injury, and everyone could see it. What followed was not enlightenment. It was a scramble. Consider the hole this left. A judge in 1220 woke up with cases to decide and no lawful method of deciding them. Ordeal was gone. Oath-helping was already in decline for serious crime, because too many people had noticed that a rich man could always find 12 friends. Nothing had been prepared to take their place, and the caseload did not pause while Europe thought about it. English records from those years show real confusion. Judges kept accused men in prison for long stretches with no procedure available. sent panels out to ask around, and in some cases simply pressured defendants to accept whatever the neighbors said. That improvised pressure hardened, over decades, into something that looked like consent to a jury verdict. Notice what got built and what got skipped. Nobody sat down to design a fair trial. The jury grew out of a gap, shaped by whatever kept the courts moving, and the protections we now think of as fundamental arrived slowly and unevenly afterward. Defendants in English felony trials had no right to a defense lawyer for another 500 years. England moved toward putting the question to juries, and over the following century, the jury slowly stopped being a body of local knowers and started becoming a body of hearers, weighing what was presented to it. That shift took generations, and it was not clean, but the modern trial grows out of that gap. Much of continental Europe went the other way. Roman canon procedure took hold, built on trained judges, written records, and a strict standard of proof requiring either 2 eyewitnesses or a confession. A high bar, in principle.
No man shall be
Look closely at that second option, though. If a conviction requires a confession, and the court is now responsible for producing proof rather than reading God's verdict, then obtaining confessions becomes the central technical problem of the system. Judicial torture, carefully regulated, hedged with rules about repetition and about corroborating detail, spread across the continent in the centuries after the ordeal was abolished. The ordeal ended and something worse took its place in much of Europe. That is the part of the story people leave out. The ordeal looks like the barbaric thing, and the courtroom looks like the civilized thing, and the actual sequence runs the other way around. Medieval courts stopped asking God because asking God had come to seem impious. And then they had to find the answer themselves, and they found it in a cellar. Step back from the iron and the water, and one question is left. What was that system for? It was not for finding facts. It could not find facts, and its designers were not confused about that. Everything in it, the public accusation, the reputation test, the counted oath helpers, the priced life, the ordeal offered as a choice, points at a different target. The system was measuring standing. How embedded were you? How many people would risk something for you? How much did the community want this to be over? Judged as a truth-finding machine, it is a failure and a horror. Judged as a peacekeeping machine, in a world with no police, no forensics, no prisons to speak of, and no way to check anyone's story, it did the job it was built for. It converted lethal private feuds into public procedure with an ending. And the price of that was paid by the same people every time. The stranger. The poor man with no kin in the parish. The widow with no one to swear for her. The man everyone had already decided about. They could not raise 12 oaths, so they got the iron. And if they ran, they got the wolf's head. A system that runs on social credit will always fall hardest on whoever has none. The court was not looking for the truth. It was asking whether you belonged, and the answer decided everything else. We did not fully leave that behind. We built rules of evidence and standards of proof and the presumption of innocence. And those are real achievements that changed real outcomes. Yet reputation still walks into court. Who will speak for you? Who can afford to take time off to sit in the gallery? Who the room already believes? All of that still moves cases. The apparatus is unrecognizable. The underlying question has proven very hard to retire. 9 paces with a glowing iron bar, and 3 days to see how the wound looked. Your neighbors would decide whether you were guilty long before the bandage came off, and the ordeal was only there to say it out loud.